of whether we can rely on WhatsApp, Facebook. The world moved a long time ago from that traditional hostility towards electronic evidence. As a matter of fact, Mr. Speaker, these days even legal documents are served on WhatsApp. You check with the judiciary, WhatsApp is a recognized method of sending and serving even official summonses and court orders and whatnot. There is legal provision, of course, for how electronic evidence is to be presented. The requirement is one for authentication, and all you need is a certificate. We have presented that certificate in the affidavit of the mover of the motion. It identifies the devices from which these WhatsApp screenshots, Facebook, whatever, were downloaded. So all you need, Mr. Speaker, is to show the path and the device. And just for the record, we have those devices before the Senate. Should the Senate be interested in verifying whether indeed those WhatsApps were downloaded using those devices as required under Section 106B of the Evidence Act, or if you like, Section 78A of the Evidence Act. Is it possible to get the context of these screenshots? Of course it is, perhaps with or without some difficulty, but we tried during the evidence in chief to show you that the governor was actually trying to misrepresent the context by misleading you to believe that the procession we saw the deputy governor participate in September is the one that triggered the WhatsApps, when the WhatsApps have their own timestamps and date stamps that show they occurred several months before that and unfortunate incidents. Do we have consent? No such consent is required. And while still on this question, Mr. Speaker, we said early in the morning, the prevailing jurisprudence is that the proceedings before you are not akin to proceedings in a court of law. So those strictures about the rules of evidence and whatnot, even though we have complied with them, we've only done so ex abundanti cautela, out of abundance of caution, not because we were required or in any event obliged. And the sections of the law, Mr. Speaker, to be found in page 44 of our volume 3. There is a section, there are sections from the Leadership and Integrity Act, which is a direct derivative of our chapter 6. It has all those sections we've cited there. The one on bullying is at page 49 of our volume 3. And I could go on and on, Mr. Speaker. All we are trying to say,
Council, we're really running.
All we are trying to say, Mr. Speaker, is that these are valid grounds of impeachment, and if we doubt that they are, let us think how sustainable it is to have a county being run like that. We've already seen, because of this persistent campaign, matters escalating to levels of violence. We hope will remain at where they are and they will not escalate further. Thank you, Mr. Speaker.
Senator Wambua.
Thank you, Mr. Speaker. Mr. Speaker, my question is directed to the Council in relation to what the Honourable Member of Parliament is confessing on the floor. Mr. Speaker, there is open, obvious aggression between the two parties, and is playing out in the public. I want the Council to tell us and help us to make a decision on this aggression, whether there is a requirement in law for the governor to be a friend of the other elected leaders in the county, or whether in the converse, the elected leaders in Meru County have an obligation to also maintain a relationship with the governor. I thank you, Mr. Speaker.
Proceed, Council. Under 1 minute, please.